resume the recording and stop sharing. So good evening, everyone, and welcome to International Human Rights in the Supreme Court 2021 term, organized by the Washington Foreign Law Society with the co-sponsorship of American Society of International Law and the ABA International Law section. I'm Giuliana Canet, the president of Washington Foreign Law Society, founded in 1952 to promote knowledge and understanding of international legal matter, comparative legal issue, and foreign law. Given the number of participants, you will be muted during the webinar, but you are able to communicate with us and the panelists via the Q&A section. Please send your question for our distinguished panelists using the Q&A section on your screen. We'll get to your question toward the end of the presentation. This session will be recorded. Don't forget to follow us on Twitter, and I will put the link on the chat soon, and on LinkedIn. Let me introduce our moderator for this evening, Mark Feldman. He has practiced law for 60 years, including 16 at the State Department, where he was deputy and often acting legal advisor. He teaches foreign relations law at Georgetown and is well known as one of the drafters of the Foreign Sovereign Immunity Act. One final note before I hand the floor to our panelists. As Mark mentioned, please consider becoming a member of the society. There is a discount rate for students and government employees, and I will put the link on the chat. So welcome, Mark. Welcome, panelists. The floor is yours. Thank you.
Thank you very much, Juliana. I want to thank the Washington Foreign Law Society for sponsoring, producing this program, and our very distinguished panelists for giving us from their valuable time, and to welcome all the attendees. We had a huge registration. There's always a certain fall off from the registration, but there are already 80 people watching the program. So let me begin by saying we have a great panel. Most of you know Laurie Fisler-Damrosch as the distinguished law professor at Columbia University, past president of the American Society of International Law. She inherited, if that's the right word, the mantle of the great Lou Henkin, who when I was practicing, during many of my earlier years of practice, he was, I would say, the dean of the international law professors, and we remember him fondly. I know or knew Laurie in a different way as a young graduate from Yale Law School, if memory serves. She came to the State Department in the Carter years in an influential position as a special assistant to the legal advisor. And as I remember, her view of the Filartiga case, that is to say that the State Department, the United States government should support the adjudication of that torture case under the Alien Tort Statute, prevailed over mine back in the day. We've been talking about these issues for a long time.
That must have been the only time that my view prevailed over yours. I'm going to go back on mute.
Tom Lee is a new friend. We filed competing briefs, dueling briefs in the Supreme Court recently in the Simon case that we'll be talking about tonight. But I've been a longtime admirer of his scholarship on the Alien Tort Statute. He, unlike most originalists, he's also an original. He has his own point of view. He contributes information about the intent of the actual originals, the framers of the Constitution. And even when we disagree, it's always fun to read what he has to say. Now, Robert Barnes, the Supreme Court reporter for the Washington Post, I think is well known to everybody who may be on this call, who reads the Washington Post on a regular basis. He doesn't want to tell us much about his early life, but he wants a short introduction that tells us that He's been at the Post for 27 years. And lately I've been reading him almost every day, and sometimes on the front page even. He wrote a piece about the Philip case, which is one of the centerpieces of our discussion tonight, which was published on February 3. He also wrote a couple of great pieces about the student speech case, which he called the Cheerleader's Rant. And he published that one on April 25 with a follow-up piece on April 28, when it became apparent that the court wasn't going to make as much of the case as we had thought previously. I'm going to be very brief, but I do feel the need to provide just a little bit of background to tee up the discussion, which I expect to be quite lively. When we organized this panel, we were focused on the fact that the Supreme Court had granted certiorari in 4 cases involving international human rights, the adjudication of international human rights in U.S. courts. 2 under the Alien Tort Statute involving child slavery in the cocoa plantations in Africa. Unfortunately, they haven't decided that case. It's still pending. So we will not have the opportunity that we expected to tell you what they said or to criticize what they said. But I'm hoping our panelists will be able to fill you in on the broader background, the course of decision, and give you some ideas of their ideas, which may differ as to how this case is going to come out. I'd like to say more. We also had 2 cases under the expropriation exception to the of the Foreign Sovereign Immunities Act, and these cases have been decided. The one case was both of these cases arose out of the the genocide of European Jewry in World War II. One case, the Philip case involving the Federal Republic of Germany, was a claim to title or compensation for a treasure of church relics and church cultural objects that allegedly have been subject to a confiscation, that is to say, to a forced sale in the Nazi period. The other case against Hungary, the Simon case, involved a claim for damages against the railroad, the Hungarian railroad, who allegedly stripped hundreds of thousands of Jewish victims of their possessions before shipping them off to the extermination camps. These cases, when the Supreme Court granted cert in these 2 cases, it was essentially on 2 issues. And to put it in perspective, let me just say that there was a split between the 7th Circuit and the DC Circuit, which forced the issue to the Supreme Court. The 2 circuits agreed that the expropriation exception was generally not available to claims, did not apply to claims by victims of foreign expropriation when they were the citizens, when the host state was taking property of their own nationals, because international law generally did not recognize, in most cases, state responsibility for takings of property from your own nationals. So this is called the domestic taking exception, pretty universally established. But both the 7th Circuit and the DC Circuit held that pursuant to international human rights law, particularly the Genocide Convention and the common law that follows it, that the taking of property as part of a genocide was a taking of property in violation of international law that was covered by the expropriation exception. And that's where their agreement ended. The 7th Circuit, in a couple of cases, basically introduced the doctrine of exhaustion of local remedies. and refused the claimants the right to go ahead with the case until they had established either that there was no remedy or that they had exhausted it. That argument was evolved a little differently in the DC circuit, where the claim was pressed and supported by the United States government that in the context, not just of the expropriation exception, but more generally under the Foreign Sovereign Immunities Act, the courts were permitted to abstain from exercising jurisdiction where that jurisdiction was established on the basis of international comity. And the State Department, of course, was interested in having the courts consider the views of the government on the merits of a particular case. So the Supreme Court granted cert on two discrete issues. The comity issue was common to both cases, Philip being the German treasure case, and Simon being the Hungarian damages case. But in Philip, the Federal Republic of Germany requested, and the court granted cert on another more fundamental issue that was not raised on petition for cert by Hungary. And from the very, and that basic question, to paraphrase it, was, does the expropriation exception apply to cases involving genocide or other international human rights? And in the end of the day, that's all I'm going to say about the case right now. Leave this to the panelists. The Supreme Court ruled 9-0 in the Philip case that the court would that domestic taking exception applied, notwithstanding the finding of genocide. In other words, that they decided that there were two separate bodies of law, and that this one relating to the expropriation of property and the other relating to international human rights. And in the view of the Supreme Court, as I say, 9-0, the expropriation exception, Section 1605A3 of the Foreign Sovereign Immunities Act, applies only to the international law of property and not to international human rights. And that's where we stand, leaving open or in place the circuit split over the issue of comity, whether that discretion is available to the courts. The Court of Appeals in the District of Columbia had held that it is not. And with that introduction, I'd like to pass the baton to Laurie Damrosch, who has lived with all these issues, and she and the other panelists are going to address both the FSIA and at greater length the Alien Tort Statute. Thank you, Laurie.
Thanks, Mark. So I hope that my audio is okay. If any problems with the sound, let me know. So thanks for giving the very full explanation of the Philip and Simon cases. These are not the first encounters that the Supreme Court has had with Holocaust era cases. We can, and indeed, I think what I want to say is that we've had several 21st century cases involving Holocaust era takings and Holocaust era killings and other such human rights problems. And so we are seized in the 21st century with trying to apply today's law to facts of long ago. And in 2003, in the American Insurance Association versus Garamendi, the Supreme Court had dealt with problems of federal preemption in the context of a state regulation that had to do with Holocaust era claims. In the 2004 case of Republic of Austria versus Altman, which is closer to our most recent cases, the court was looking at the expropriation exception specifically against a claim that you couldn't apply modern foreign sovereign immunities law to events of a very long time ago when an absolute view of sovereign immunity prevailed. And the court on that occasion, rejected the idea that we would apply really old law of sovereign immunity and said we have to take the 1976 Act and we have to look at the exceptions under the 1976 Act to all claims that are brought to US courts in the modern period, even if the events occurred a very long time ago. So that case was then remanded, and the result of it is that Mrs. Altman won her claim, and we have the possibility of seeing the painting of her relative whose painting was seized a very long time ago here in New York City at the Neue Galerie. So now, from the human rights perspective, the plaintiffs and the heirs, they were the respondents in the Philip case, the heirs to the seized property, made a very powerful case, which I think is correct, that when there is a coerced sale of property for a fraction of its value as part of a campaign, not only to take property, but to deprive German Jews of their property on a discriminatory basis, and also to eliminate the Jewish people as a racial and a religious group, that act of genocide is the kind of discriminatory taking that qualifies as an expropriation substantively under the criteria that are now required to be applied in the United States under the Foreign Sovereign Immunities Act. That, textually speaking, the expropriation exception speaks of a taking of property in violation of international law. And when the taking of property is part of a campaign to exterminate the people whose property is being taken, that fits very naturally within the literal wording of the expropriation exception, and would, I think, give effect to the purpose of that statutory exception. Now, what the Philip court did in their unanimous opinion saying that the expropriation exception did not apply to this case is they took a procedural component of the international law of international claims and they erroneously elevated it to the substantive status of the international law of expropriation. And this is a mistaken view of the substantive international law of expropriation. It would wipe out a whole category of cases in which the taking in violation of international law involved the commission of genocide or other equally serious human rights abuses. Now, notwithstanding this erroneous interpretation of the phrase in violation of international law, where a taking by a state of the property of its own nationals is concerned, the Roberts opinion, unanimous for the court, does not completely foreclose all takings claims involving genocide or other serious human rights violations. The court viewed its prior decision in the Altman case, which I referred to. There, Mrs. Altman had been a Czechoslovakian national. She happened to have subsequently acquired US citizenship, but the court referred to her as a Czechoslovakian national. So if we had had, in the context of the present case, the taking of property of a third country national, the court seems to be saying that it doesn't have to be an American national whose property is taken. So that's one aspect of what the court left open that I think we can take some comfort from. That is to say, those of us who think that there's at least some space in the expropriation exception and in the Foreign Sovereign Immunities Act overall for consideration of some kinds of serious human rights violations. So the court expressly left open and direct the Court of Appeals on remand to consider the alternative argument of the heirs that the victims of the coerced taking were not German nationals at the time of the transaction. And this reserved issue does not appear to require that the claimants would have to show that they were American nationals or even that they were Czechoslovakian nationals or some third country. I would read that reserved issue as allowing for the possibility that if the German Jews were being denationalized and rendered stateless and deprived of any nationality whatsoever, having previously been German, that might leave open the possibility that the expropriation exception could apply in their case if they had been rendered effectively stateless as an involuntary and arbitrary act under Germany's Nuremberg laws. So now I want to say a couple more things. Mark, you'll have to let me know how much time. I wanted to make a few more points about the Philip case before turning to the Nestle and Cargill cases. Do I have a little bit more time? Okay, so I think there are a couple of really interesting things about the Philip opinion having to do with the relationship of the Foreign Sovereign Immunities Act to international law, and even the Supreme Court's stance toward the International Court of Justice, where it had some really curious, almost ironic things to say about a ruling of the International Court of Justice in a Holocaust-era claim involving jurisdictional immunities of the state of Germany against Italian litigation on behalf of Holocaust victims. So first of all, about the relationship of the Foreign Sovereign Immunities Act to international law in general. In a number of earlier cases, the court had referred to foreign sovereign immunity as a matter of grace and comity. Now, others on the panel are going to talk about comity, but in those earlier cases, you would have gotten the impression that the court was saying that foreign sovereign immunity is just this nice thing that we unilaterally do, but it doesn't necessarily arise in a framework of international law. So I think it's quite interesting here that the court has picked up the fact that international law is actually relevant to interpretation of the Foreign Sovereign Immunities Act and to the possibility that US courts, by erroneous interpretations of the Foreign Sovereign Immunities Act, could place the United States in violation of international law. Now, there are a few things that are curious and even odd about the court's treatment. I think one of the most curious, and Mark, I think you and I are in accord on this, is that the court is taking its snapshot of international law as of 1976, when the FSIA was enacted, and it does not seem to entertain the possibility that international law evolves over time. And in earlier cases, for example, in Sosa versus Alvarez-Machain, which was not an FSIA case, but it was an international law case. It involved the Alien Tort Statute that I will talk about next. The court said, we don't freeze the law of nations at the time that the Congress enacted a statute having used the term law of nations. And similarly, there's no logic, I think, to freezing customary international law as of 1976 or to referring to the restatement second as evidence of what Congress must have had in mind in 1976 when it was framing the expropriation exception. The court should be looking at international law today, and indeed it should be doing what the restatement fourth says about the relationship between international law and US law. In the restatement fourth, the restators have said that although customary international law on jurisdictional immunity of foreign states is not directly applicable in courts in the United States, it can be relevant to interpreting the FSIA and understanding its significance. So, all right, that was one point. Now, on the reference to the International Court of Justice, here the court says, the Supreme Court says, that courts should be attentive to the possibility that their own decisions can place the United States in violation of international law. It referred in this context to the ICJ decision in 2012 in the jurisdictional immunities of states and their property, Germany versus Italy. And it seems to be saying, you know, we, the Supreme Court, want to pay attention to what the ICJ has told us about the customary international law of sovereign immunity, because if we were to ignore or overlook that, then Germany here would have the same kind of grievance against the United States that it had against Italy that the ICJ had upheld in 2012. Now, why this is so ironic for me from the human rights perspective is that in a whole series of cases, culminating in Medellin versus Texas in 2008, where we had not just any old ruling of the International Court of Justice, but a binding judgment directed to the United States. The Supreme Court, also through Chief Justice Roberts, but not in the same unanimity or the same posture that we have in the present case, had said, we'll give respectful consideration to the pronouncements of the International Court of Justice, but we don't consider that they are directly applicable to the United States, even in a case where the court there acknowledged that there was an international obligation to carry out the binding ICJ judgment. So Okay, so I think I would just wrap up on the Philip case by saying that the court seems to think that there was an all or nothing choice between confining expropriation to the classic taking by one state of the property of a foreign national, that on the one hand, and then on the other hand, an all-purpose human rights exception. It said, and I think correctly so, the FSIA does not create an all-purpose human rights exception, and the court didn't want the expropriation exception to become transformed into an all-purpose human rights exception. But they could have and should have, in my view, found within the expropriation exception, based on well-established international law about discriminatory takings, enough room to say that a genocidal campaign, discriminatory, persecutory against a group on the basis of its racial or religious or ethnical or national identity, does fall within the expropriation exception. So that's what I wanted to say about Philip.
Thank you, Laura. Why don't you give us 5 minutes on the ATS?
Yes, okay. So I can do that. Thanks. So Mark made mention in introducing me that, yes, we go way back to the Plurality case. And he was a venerable deputy legal advisor, and I was a brand new, freshly minted special assistant to the legal advisor. But in 1980, we worked together under the direction of the then legal advisor, Robert B. Owen, with others in that office and in the Department of Justice and throughout the government, to come up with a coordinated position that torture in violation of the law of the law of nations in the 20th century states a claim under the Alien Tort Statute. That, as I'm sure our audience knows, was a case involving torture committed by a Paraguayan against a Paraguayan in Paraguay, but the plaintiff and the defendant both happened to be found in the United States at the time the case was brought. And that case of the Second Circuit in 1980 inaugurated the modern era of Alien Tort Statute cases. Now, the cases that are before the Supreme Court right now, and where we're sitting on the edge of our seats wondering what they are going to decide, involve the application of that same principle to claims where the defendant is a corporation. And so I want to say a personal word here. In the 1990s, when these cases against corporations were first being brought, there was a famous case called Doe versus Unocal, involving egregious human rights violations being committed in Burma, Myanmar, which were said to involve forced labor tantamount to slavery, so that the underlying human rights abuses were as egregious as the torture in Filartiga. And the human rights at issue were of the sort that can, in principle, be committed by private persons, and the defendant was a US corporation. I took a particular interest in those cases because the defendant was the company formerly known as the Union Oil Company of California, which my father worked for 40 years, and they sent me to college on a Unical scholarship, Union Oil of California scholarship, and my entire life has been bound up with the then Unical Corporation. And when I wrote some lectures that I delivered at the Hague Academy of International Law in 1997 under the heading of Enforcement of International Law through Non-Forcible Measures, I had a few words to say about the Alien Tort Statute in claims against corporations. And it seemed to me then, and it seems to me now, that there is no better place to sue a United States corporation when it is responsible for the perpetration of serious human rights violations than in its own home jurisdiction, namely, in that case, California. Now, you said 5 minutes. I guess I'm pressing the limit here, but I want to say that the Supreme Court is now on its third or maybe fourth attempt to address this underlying question of whether corporations can violate the law of nations within the meaning of the Alien Tort Statute. And the circuit split had been created many years after the Unical case, when the Second Circuit held in a rather categorical way that corporations simply are not the right kind of person against whom an ATS claim could be stated. So the Supreme Court granted cert on that question. I guess it must be almost a decade ago now, and they couldn't agree on it. The case was argued twice, and the second time around, the court said, we're just not going to decide the question about corporations right now. We're just going to say that on the facts of that case, which involved foreign plaintiffs, foreign defendants, and all of the activity in the case going on in a foreign country, the court said in these sorts of F-cubed, foreign cubed cases, the presumption against extraterritoriality should apply. And they reserved for another day the question of whether corporations can commit a violation of the law of nations within the meaning of the ATS. Then a few years later, another case against a foreign corporation was taken up by the court. That was the case of Jesner versus Arab Bank PLC. And there, the corporation was a foreign corporation, and a very fractionated court could not agree on much of anything. Let's see if I can even find my notes on how fractionated they were. Yeah, they split umpteen different ways. Well, they split so many ways. There was a plurality opinion by Justice Kennedy, and different parts of his opinion were joined by Justice Thomas, Justice Alito, Justice Gorsuch. Several of them wrote concurrences. There was a dissent by Sotomayor, joined by Breyer, Ginsburg, and Kagan. Essentially, you had something like 6 different opinions, all coming out every which way. But they did reach a majority to dismiss the case on the ground that a foreign corporation should not be a defendant in an ATS suit. So that fractionation, the inability of the court to have a clear picture of what is the underlying logic of the Alien Tort Statute and the underlying relationship of the Alien Tort Statute to the foreign relations of the United States, and differences of opinion about the relevance of suits against foreign corporations to the foreign relations of the United States. All of those threads in the case and those multiple opinions leave us the legacy that the present court, which is differently configured and no longer has Justices Kennedy or Ginsburg, and now has Justice Kavanaugh and Justice Barrett, who are going to give us their views on some of these questions for the first time in this capacity. Clearly, they're struggling with it. I don't have a crystal ball. The only thing I can say is that I remain committed to the proposition that there are certain kinds of human rights violations that can be committed by private actors. There are certain kinds of human rights violations that can be committed by private corporate actors. And the best place to sue a US corporation is in its own home jurisdiction. Discovery and everything else will flesh out the facts, but the legal proposition that a US corporation that is alleged to have committed human rights violations needs to respond in the usual way, I think is a sound one. Thanks for giving me extra time, Mark.
Well, I took more of your time. That's perfectly fine. Well, let's see whether Tom Lee has more of a crystal ball, and whether he shares your views. Tom has written extensively on the Alien Tort Statute and has some real insights into what the framers had in mind. You have the floor.
So I'll begin with a prefatory remark, which is, I think genocide is obviously a crime against humanity. In other of my scholarship, I've written about how I think genocide is a valid reason to go to war. Humanitarianism, which is not the US position, regardless of whether or not the Security Council has approved, regardless of whether or not there's a self-defense justification, that is not the position of the United States. That is the position of Great Britain. And I think a few weeks ago, there was a marvelous talk between Mark and Jeff Smith, who had been a lawyer at the State Department, and he told a wonderful story about how he had been present at the South Korean trial of Kim Dae-jung for treason during the dictatorial regime of President Chun Doo-hwan. and essentially his mere presence at that Korean national criminal trial produced a change in the outcome, whether or not it was explicitly said by the South Korean government. So genocide is awful. I believe in human rights. I just don't think international human rights law, that the Supreme Court is the right vehicle to deliver the United States commitment. I think these are political commitments. I think it's a valid jus ad bellum. Sending State Department lawyers to give pressure to foreign governments, that's something that we should do, but I hesitate to believe that rights of action should be advanced in US courts. And I think that sort of accords with sort of my understanding of the Alien Tort Statute's original meaning. And Lori, I think you'll remember I had a job talk at Columbia in 2005, the year after the first ATS decision by the Supreme Court was decided. Lou Hankin was there, Lori was there, Jeremy Waldron was there, Jerry Newman was there, and my argument was this thing is not an international human rights statute, it's a US national security statute. It's meant to police violations that under international law that the US might be held accountable for. It has nothing to do with sort of vindicating foreign cube suits, the rights of foreign plaintiffs to bring suits against foreign defendants with regards to claims in foreign territory. And I sort of argued that made sense because the United States in 1789 was not a world power, it was a weak state. And they were very worried that the European powers would wage war or break trade. And so they wanted to provide US courts as a mechanism for giving relief, so that because under the international law at the time, if the United States was responsible, then the other country could wage war. And so Alien Tort Statute means simply a non-contract injury to the person or property of a foreigner with whom the United States is at peace or neutral, which included pretty much everyone in 1789. So I see the Alien Tort Statute as a national security statute. Now, my prediction for Nestle Cargill is I actually think that Nestle and Cargill will win. It will probably be 9-0 or 8-1. Sotomayor may dissent. It's much more difficult to see what the common ground is. But my actual position is, Lori, you'll be shocked to hear this. I actually agree with you that US corporations should be in theory liable under this statute, right? Because if you think about the original design of the thing, it was to make sure that there was a federal forum available for people who thought the United States had somehow violated international law. And so I think that they should maintain that sliver of the statute. Now, the reason why I think it'll be 9-0 nonetheless is because the facts of this case, and I'm not going to get into it, involves allegations that Nestle and Cargill, by buying cocoa from countries that had this exploitative means of child labor, had somehow aided and abetted these violations. So I think there's a number of lawyerly ways that you can wiggle out and still maintain the principle somewhere that US corporations can still be liable. And in fact, Justice Gorsuch's opinion in Jesner makes a point, which I think is actually wrong. He thinks that basically in an ATS suit, the defendant has to be a US citizen, because basically he believes that the ATS is cashing out the diversity jurisdiction under Article 3, which means you have a foreign plaintiff and a US defendant. And so if you have a foreign plaintiff and a foreign defendant, that's not bring under the Alien Tort Statute. He happens to be wrong, because if you know international law at the time, it didn't matter who the tortfeasor was. So if you were in the United States and you were a British national and you were injured by a Frenchman, the United States was still on the hook because it was the territorial sovereign. So I think that theory happens to be wrong, but Gorsuch has written that position into his Jesner opinion. And so I think that we might actually see more votes than we were expected, preserving the idea that some level of US corporate liability has to survive, right? And so that's, and I'm sort of jumping around a little bit because I wanted to talk first about Hungary versus Simon. And I think Mark and Lori have already discussed it quite a bit. And I want to focus on a couple of issues. So one, in the Simon, in the Philip case, the 14 plaintiffs were all German nationals at the time of the alleged expropriation in 1935, right? So in some sense, it's tricky because if you know the history of Germany, in 1935, and the allegations say that basically the treasures were sold for 1/3 of their fair market value, and they had been bought during the Weimar period anyways. And so there's a lot of bit of trickiness in the facts here. And so it's not as compelling a factual pattern, which is why it's not surprising to me. I actually had told friends that I wouldn't be surprised if this came out 9-0, and you know, I mean, and it did. I would have wanted it to come out 9-0 on the other ground. The other point I want to make about the FSIA case is we're seeing what I think is a troubling tendency of the Supreme Court to view any issue related to foreign sovereign immunity as an issue implicating statutory interpretation of this statute, right? The Foreign Sovereign Immunities Act. They seem to be inclined to the view, which Justice Scalia has held since 1988, that the FSIA is sort of the answer, the place you look at, the Da Vinci Code for any issue involving foreign sovereign immunity. And anytime you have a case, you have to decide it as a matter of statutory interpretation of that particular statute, right? And that's exactly what Chief Justice Roberts does. And I actually, again, Laurie, I'm going to surprise you twice because I agree with you, overread in violation of international law, right? I mean, if there's a taking in conjunction with the genocide, if this had been 1943, not 1935, I mean, there's no doubt that that would have been a slam dunk violation of international law, and that international law could evolve, notwithstanding the Supreme Court's holding in Altman, right? And so I think I have the same position on in violation of treaty or law of nations under the Alien Tort Statute. So I'm not being inconsistent here. So, but it's sort of indicative of the extent to which the Supreme Court really wants to decide all of these cases as a matter of statutory interpretation. They don't want to go on the way that Professor Estreicher of NYU and I wanted the Supreme Court to go off. And this is the issue on which Mark and I are on separate sides of the aisle, right? So the case that we had filed briefing on was the companion case of Hungary versus Simon. And that involved allegations against the government of Hungary for their complicity in sort of shipping out Hungarian Jews for various atrocities, right? And so the point on which Mark and I disagree is this, which is, so if you are bringing such a claim and a federal court says, look, we're sympathetic, but we really want you to go back to Hungary and litigate there first, right? Mark thinks the court can't do that. Professor Estreicher and I think that they can do that, right? That basically, and again, the presumption is the Foreign Sovereign Immunities Act, if you're not within the immunities, you have jurisdiction and you must exercise it outside of the enclave of certain settled doctrines. One of them is foreign non-convenience, which was what the lower court did here. That's the idea that this is not the most convenient forum. The witnesses and the key testimony is somewhere else. So Professor Estreicher and I filed a brief saying, look, we don't think that the FSIA answers that question. And we are comfortable with judges deciding, well, we really think we're not going to dismiss the case with prejudice. You could bring it again, but we really think you should go to Hungary first, because that's where it happened. So we're comfortable with that. The problem is when the lower courts do this, they have this ridiculously complicated 9-factor test where you could drive a Mack truck through this test, right? It's you could come to any result you want. It's an artifact of the 1970s when we had this concept of super brilliant judges who would know once they have the instrument how to come to the right decision, right? And so Professor Estreicher and I said, like, look, that test is out of control, but we think that this is an important principle, that federal courts, if they think that it makes sense to go to another foreign sovereign's court and try there first, they should have the authority to do. And that's sort of what we articulated in our brief. We expressed what we thought was a tighter way to guide lower courts in deciding this question, right? Now, again, and I'm going to circle back to my greater theme, which is you know, I mean, I don't have anything against international human rights. I think genocide is abhorrent, probably the greatest crime against humanity, which is why I think that it's a valid reason for a country to go to war against a genocider. I think if President Biden decided today he wanted to send troops to intervene in Myanmar, I think that would be lawful under international law. But it's a political decision. If he wanted to send U.S. citizens to monitor camps in Xinjiang and so forth and so forth. I mean, he's perfectly allowed to do that. I mean, the question is whether or not the federal court should be involved in these types of cases, and I think that basically that's a much more problematic proposition. I mean, generally, and I think I'm gonna try to make up some of this time, and I had a lot of other comments, but I know that we're running behind schedule, and I think the most important parts of these things are the Q&A. So I want to make sure that we have time for the participants to say things too. I mean, my general view of this, I mean, first of all, I want to separate my views as a scholar and my views as a lawyer, right? I think that basically what I have tried to do, and Mark said, well, you know, I sort of have an originalist take on the ATS. I mean, I have an originalist take in the sense that I spend an awful long time looking at the legal history of this thing, and my scholarship is historical in nature. I mean, if I'm in the position of a private lawyer or a public lawyer, I mean, obviously that's a very different view of doing these things. And I sort of maintain the fantasy that you could really have good scholarship that really, you know, regardless of whether you disagree or not, you actually come to some advancement of knowledge, right? And so I just wanted to make that point. And the last point I'll say about the Alien Tort Statute, and I think I made my prediction. I sort of gave my take that it's a national security statute, not an international human rights statute. One very interesting wrinkle is it's being litigated in the lower courts, this idea of derivative sovereign immunity, where government contractors for the United States are being sued, and because they're not the government, they can't be sued under the Federal Tort Claims Act, and so they're claiming this thing called derivative sovereign immunity. I have a big problem with that under the Alien Tort Statute for various other reasons, because I think that is the heartland of the Alien Tort Statute, to police the United States in US courts for violations where it might be on the hook for international law. That's it.
Well, that's great, Tom. I knew this was going to be interesting, and that I am not disappointed. I wish we had 2 hours for everybody to talk, but we are going to 6:45, and we couldn't close this evening without hearing from Robert Barnes. He will give us a different perspective. He is not a nerd. He's watching this from the point of view of the American reader of the Washington Post. What should they make of these cases? So I'm very interested to have that fresh perspective.
Well, you know, one thing I would say, a couple of things I'll say. One, Supreme Court reporters are sort of jacks of all trades, and so you know what the end of that phrase is. And so I feel a little funny being here because you guys are the experts. You're the ones that I would call when the decision comes down to find out what it means. What I guess I would say from covering these cases at the court, a few things always come through to me in these cases. One is the court sort of saying, who are we to decide? They very much, you know, on the one hand, seem to want State Department views, and they are very worried about what their decisions might do in the area of foreign affairs, and think that they don't have a particular expertise in it. On the other hand, it's what they do. They try to decide them as lawyers, I think, as you guys have pointed out. You know, I think that the other thing that I hear a lot from them is that they feel that they are sort of inventing law, especially with the Alien Tort Statute, and that, you know, this thing was around forever. It only became, you know, their problem not that very long ago, and they don't know quite what to do with it, or I guess some of them do, and some are in the middle. On the two cases that we've been discussing, I think, you know, a 9-0 decision means either that the issue is really easy or that it's really hard. And I think in this one, they decided that it was really hard, and they took a narrow way out of it. I'd be interested in what you folks think. I thought that these two cases could have come out differently, and I'm not so sure that the decision they made in Philip tells the lower court that much what it should do in the Hungary Simon case, but you would know that better than me. And I think with the Nestle case, there seems to be an awful lot of off-ramps for the court, depending on how split it is, and if they really want to settle some issues once and for all. I think that there was a lot of skepticism of the idea that you could sue an individual but not go after a corporation. That was expressed, I thought, a couple of times across ideological lines. I thought that there was a great skepticism about the facts of this case and whether they had really argued if they had any real evidence of aiding and abetting. These are tough cases for reporters to write about because, on the one hand, you've got the first thing out of one of the lawyers' mouth is, my clients don't really support child slavery. And that seems like a pretty good story. On the other hand, as we've seen, it is a very technical field, and I think difficult for us to write about in a way that captivates the public. And so I'll in there except to say, I'm often asked, as a reporter, how do you keep from putting your own opinion into an article? And my answer is that the Supreme Court beat is probably the easiest one in the world to not have to do that, because you have two really good, you have very good arguments on both sides done by very smart people. And so I usually don't exactly know how I think something should come out. And we got a very good example of that already this evening.
Well, thank you, Robert. I hope you'll join in, continue to share thoughts with us as we go forward. That's very helpful. I'm looking at some of the questions that were put on the Q&A even before we began this talk. And one of them has to do with the question of what are the implications of these cases, that is the two that have been decided and the ones in process under the ATS, for the role of customary international law in US as a rule of decision in US courts. And Laurie has already addressed that in part. My sense for what it is that there has been a tectonic shift in the US law and legal philosophy on that point from the time of the framers to today. There is no doubt that the framers believed, they were, of course, were natural lawyers. It was before the era of positivism. They thought that the customary international law was part of the law of the ambient law of the United States, and that nothing could be clearer on that point than John Jay's jury charge charge to the jury in the Henfield case, which was the prosecutions under George Washington's Neutrality Proclamation, where they, under common law doctrine, they were trying to prosecute, even without a US statute, prosecute Americans when it was found that they were in violation of the law of international law of neutrality. I think this court today is very, very far from that, and the prospects for applying the customary international law are very dim. I would only mention in this respect Justice Kavanaugh's writings, where he doesn't even mention Sabatino, which is the case that stands, I think, for the proposition of a federal common law of foreign relations. But I'd like to hear what our panelists say about it. What is the future of customary internet? Tom, I know that you have some thoughts. I'd like to hear them, and then Laurie can respond.
So I actually had published in a volume that was recently released, which was edited by Sarah Cleveland and Paul Stephen, about the new fourth restatement. I sort of explained what the difference in customary international law between the third and the fourth restatement was, right? And the basic thesis of that chapter was, well, in the third restatement, which Lou Hankin had a very large hand in, there was a desire to play offense with customary international law, use it for human claims under the ATS. What happened between the fourth restatement, which was done in 2019-20, was the whole revisionist reaction against it. And so the point I made is, in the fourth restatement, there's much less customary international law, and the restatement plays defense and doesn't try to make affirmative claims for it. And I think that that's pretty much the future. I think, as Laurie mentioned, it's very, I chuckled when I saw Roberts' citation to the ICJ opinion in the Phillip case, because of course I teach Medellin, and these cases that Roberts had written on the other side, essentially sort of throwing sand in the face of the ICJ. So we can see customary international law cited as statutory interpretation, perhaps, but it's not going to constitute sort of an independent category going forward.
Laurie, you have a thought on that? You're muted.
Yes, I just was turning off the mute. So, I agree with everything you said, Mark, about the tectonic shift that has occurred from the late 18th century and the early 19th in the founders era, and then at the turn of the 19th to the 20th centuries, when we had in Paquete Habana, the Supreme Court still being able to say that international law is part of our law. And then by the time we get to the late 20th and early 21st centuries, it seems like the court will do anything not to have to rely on customary international law or appear that it is part of what you properly called the ambient law of the United States. And Tom, I don't know your chapter in the Sarah Cleveland and Paul Stephen volume. I'll look forward to reading it. I think it's a little bit puzzling the way you described it, because the restatement fourth didn't take up customary international law. It took up only treaties, jurisdiction, and immunities. So all the things that Henkin et al. Could say about Sabatino and all of that have to be submerged into the micro details of reporters' notes on the active state doctrine and things, and not for the core propositions about how the major judicially created doctrines that have to do with the external relations of the United States just belong in federal courts and rely on law that is generated in part outside the United States. So I bemoan, I regret this shift. And that's one reason why I seized on that little snippet in the restatement fourth about the value of using customary international law as part of the interpretive backdrop for the Foreign Sovereign Immunities Act. I think we can hope that the court, in a more maybe in a different configuration from the one that we have now, will be able to turn a little bit more back to the founders' view that the United States must comply with it, and that the courts are the right organs for ensuring that the United States does comply.
Okay, there are a couple of points of Bob Barnes has raised that I'd like to put in play here in the general discussion. One is the reticence. I think and I don't want to put words in your mouth, but I know that you wrote about the case that the court seemed to be having, about the oral argument in the Cargill case, that they were having difficulty with the question of eliminating corporate liability. And one of our attendees has raised the question, what is the future of corporate liability? And I remember a forum some years ago after when this case, as Lori pointed out, this has been on the agenda for some time now, where Harold Coe said, he came in and he said, Nazi, bad. Nazi ink doesn't matter. I mean, give me a break. I mean, I don't understand where the Second Circuit, I think, vetted this idea, and the Supreme Court in Jesner has carried it forward. I don't understand the concept of how a corporation could not be exposed if, in fact, was involved in violating a clearly established, let's say, genocide. I mean, at Nuremberg, of course, they didn't prosecute corporations, but they prosecuted individuals for things that corporations did. But so I'd like to know what the panelists think about corporate liability. Is it possible that this court, which is very protective of corporations, is going to reverse itself in some way from what they were saying in Jesner? I mean, other scholars and journalists have written that they thought that the court was going to go that the opinion, the way it was written, showed that they had that they were going to come out, that the Kennedy opinion in particular was going to conclude that there was no corporate exposure, and that he changed his mind at the last minute and wrote this very funny Jesner opinion, which limited the holding to foreign corporations. What do you think? Is there a possibility that they may change? Anyone want to speak to that? So tell me what are the rationales
Yeah, I mean,
for excusing corporations.
mm-hmm.
What is the court thinking about?
Yeah, I mean, you know, I think one of the reasons why I'm guessing that at least 8 of them are going to take one of those off ramps that Robert mentioned is precisely this, right? Because it's going to be hard to read some rule maintaining some sliver of U.S. corporate liability into that Kennedy opinion. I mean, to be perfect, and now I'm going to become a nerd. Obviously, it's not a controlling opinion; it's a plurality. He only had 2 people actually join his reasoning on this part, and so it's not necessarily controlling in that respect. But I do think that there was some tension from the way Kennedy had written the opinion. I forget who joined. I think it was Thomas who joined in full. Was it Thomas and I forget who the other one who joined in full, but you know, there is some tension there. And again, my hope is that they preserve some sliver of US corporate liability for violations where the United States bears responsibility.
Bob, do you want to expand on this at all?
I mean, I thought it felt that way, that they weren't ready to, you know, I think in general, the court doesn't like to draw those kind of lines if it doesn't have to. And so I thought that that's the way it seemed to be going. You know, one thing that doesn't quite answer your question, but I thought that was interesting in Jesner was Justice Sotomayor's dissent, which we all think of her as sort of a liberal champion and sort of human rights defender and friend of the criminal defendant. But I also thought that in that you saw the corporate lawyer side of her come out. And we often forget that that is a part of her background as well. And I thought that dissent kind of put those 2 things together.
Thank you. I would like to make one comment before we close, and we're coming to the end. I'd love to continue this, but we have a commitment, everybody concerned, to adjourn at 6:45, and Juliana's going to pull the plug at that time. But I'd like to explain why I don't agree with Tom on the issue of deference. There are 2 conjoined issues: the exhaustion of local remedies in an expropriation case, and deference to the U.S. government. And I filed a brief that I was my own counsel and in my own name as one of the drafters of the Foreign Sovereign Immunities Act, taking the view that the whole purpose of the statute in the first place was to transfer determinations of foreign state immunity from the State Department to the courts for a number of reasons. And some of this is, we discussed at an earlier webinar. If any of you are so enchanted by this program and you want to see, to hear more discussion about foreign sovereign immunity, you can find the recording on the Washington Foreign Law Society webpage of a very interesting discussion on September 17th of last year, where Judge Royce Lamberth and John Bellinger and I discussed some of these issues in when the cases were being briefed before they came down. And my testimony, I call it testimony, it was an amicus brief that I did in the Simon case, and I did not submit it in the Phillip case because I could not address from my own experience the issues in that case. But not only was it the purpose of the statute to transfer, to get away from political decision-making, to get to establish new, to provide statutory guidance for a judicial, an independent judicial objective judgment that would not be influenced by foreign government pressure or congressional pressure, and where the private parties as well as foreign states could expect as objective a ruling as human nature permits. And the other thing was I know for a fact, and that because I worked on these expropriation cases for 10 years at the State Department, that there was bitter resentment in the private sector of the government's management of those cases, and they were very eager, and the Congress, under intense congressional pressure, to provide a judicial remedy in the courts. And the idea of that an expropriation case in particular, let's just put the case where it's an American investor that has a claim against a foreign country under a revolutionary socialist government, let's say, that expropriates American property alone, and a court is going to be, and by the way, this is not an international human rights court or a human international court of claims, because the built into the Foreign Sovereign Immunities Act is a pretty demanding standard for a territorial nexus to the United States. The expropriation provision requires a commercial connection, and we don't have time to go into all the details. So the legislative history on this is absolutely convincing. It would be unthinkable from the point of view of the drafters in the executive branch and Congress to refer an American claimant to a foreign court where the expropriating government would in effect be the judge of its own case. And that applies to any other claimant of any nationality under that provision or any other provision in the Foreign Sovereign Immunities Act. That is my view of it. And there's plenty of room for difference of opinion, but we're coming to a close. Lori, do you have anything you want to do to sum up the conversation?
Well, I was trying to take a look at some of the questions that are in the Q&A that we haven't had a chance to get to yet, and we are going to run out of time. So I'll just make one observation, since we are holding this panel under the auspices of the Washington Foreign Law Society, and therefore we are interested not only in US law and US cases, but also in how foreign courts are dealing with similar sorts of questions. And I think in the Kiobel and Jesner cases, there was a strand in what the corporations were arguing and what certain of the amici were arguing on their behalf, along the lines of, nobody else has anything like an ATS, or nobody else has anything like corporate liability for violations of the law of nations. And I think that a more capacious, more expansive look, and one that's dynamic, that looks at the whole range of cases involving similar questions under foreign law, could be very enlightening. We know that most of the judges of the current court are not terrifically enamored of foreign law in constitutional interpretation, but I think there's every reason to be interested in foreign law when it comes to questions of interpretation of the law of nations under the ATS, or sovereign immunity under the FSIA. So, and I know that my foreign LLM students are producing a lot of really interesting papers on how the foreign legal systems with which they are familiar are dealing with problems of corporate liability and corporate human rights violations. So that's all I'll say. Thank you.
Thank you. Well, we're coming very close to the end. I guess I'll take the last word and thank the panelists for a very lively discussion. I feel badly that we can't deal with even a representative sample of all the questions that people have. But I do think that my closing word would be a nod in the direction of the court in the Philip case. Even though my heart bleeds for the victims of the Holocaust, I think the essential reason that it's 9-0 is a strong feeling that it is inconsistent with U.S. interests in the world to bring cases involving foreign human rights violations into the U.S. Courts out of fear on the part of the court, including Justice Breyer, who's had this concern for dating all the way back to Altman, that the United States would be hailed into court in other countries on the basis of our history. And some of that history is not pretty. And there are plenty of people around the world who would question our standing to adjudicate the norms of international law as it applies to other countries, given our own domestic problems. And I think that's felt my problem with the opinion is that I don't think the result is consistent with the statute. That's what I give to Lori. But I think there are strong prudential considerations that we're driving. And by the way, this is, of course, the articulated view of the State Department today, the Solicitor General. So I wasn't surprised at the 9-0, although I found the opinion very disappointing. Juliana, I'll pass the word to you. Say good night.
Thank you so much. Thank you, panelists. I think we have to rewatch this panel for the density of the knowledge you share with us. So to all attendees, you will see soon on our website the recording. Feel free to share with your student or best friend or whoever might be interested, and see you next event. Thank you. Bye-bye.
Thank you very much all. Good night.
Bye.